So this is People versus Michael Marvin, case number 245339. The record should reflect that Mr. Marvin present here in the courtroom today.
Sierra Coke on behalf of the people.
So Mr. Marvin, it looks like this is your first appearance here in the circuit court. You're here without an attorney. Do you understand that you have the right to have a lawyer?
Yes, sir.
Okay, and you understand that you can't afford a lawyer, one will be appointed for you at public expense?
Yes, sir.
Did you wish to request a court-appointed attorney?
No.
You want to represent yourself?
Correct, sir.
Okay. So I'm going to go through some things with you with regard to that, okay?
Yes, sir.
First of all, have you ever represented yourself in court before?
No, Your Honor.
Have you ever received any legal training or have you had any experience?
No, Your Honor.
Have you ever, do you have any kind of a legal degree or other degree?
No, Your Honor.
Okay. So I want to make sure that you understand that without any of that kind of training or experience, that there's some risks that go with representing yourself. There are issues regarding procedure in the law that you might not know about, and you might not follow some of the rules that you're required to follow, and that could hurt your case. Also, things about the substance of the law. In other words, there might be some legal defenses or arguments that could be made on your behalf that you might not know about without having an attorney to advise you on those things. Also, the consequences, you know, what kind of penalties that you could face and what your options might be. An attorney could help advise you of all of those things. And so without having that kind of advice, you could have a worse outcome in your case. Do you understand?
Yes, sir.
Knowing all of those things, did you still want to represent yourself?
Yes, sir.
Okay. So I find for the purposes of today's hearing that your waiver is knowing and voluntary and unequivocal. In other words, you're sure that that's what you want to do?
Yes, sir.
Okay. So all of that being said, Ms. Koch, have you had any discussions with Mr. Marvin? Have there been any plea offers?
Yes, to both of those. The plea offer was to the drunk driving third, dismiss the additional, the RNOs and the open in-tax charges. Mr. Marvin wants to have a trial. I talk to Mr. Marvin at least once, sometimes twice a week, maybe more. And he is considering filing a suppression motion. I sent him the blank scale motion, told him that I can't give him legal advice, but procedurally, this is how you file a motion if you want to. We talked about, he wants to have his wife come in and testify that he has a habit of driving places and then getting drunk at those places, and she comes and picks him up. I advised him if he goes down that road at trial, that I'm going to ask that his prior drunk drivings come in. They would not come in otherwise. So, you know, opening the door could be bad for him, and he should have an attorney. I advise him regularly that he should have an attorney, but he doesn't want to. He also discussed the reason marijuana was in his system. I told him that's probably not relevant, and I would object if he tried to bring that up in trial, because it doesn't really matter why he had the marijuana in his system. But we went over those issues. I think we're ready for trial. I'd ask the court to set the trial, and if he files a suppression motion, we can run it. We already ran a preliminary examination, and I think he did a request to get the transcript today, so we can go from there.
Okay, and just because so this is based on intoxication involving alcohol, right?
Alcohol and marijuana.
All right, so Mr. Marvin, is that correct? You wanted to proceed to trial?
Everything she said is correct. Sir.
All right, so Ms. Koch, you said how much time to be ready for trial?
We can set it out like 60 or 90 days, depending on the court schedule, and that would give him time if he decides to file that motion to suppress to do so.
If I set this for trial in 90 days, is that enough time for you to be ready?
I would tell you, Your Honor, that I'd like as much time as I can. I don't feel like I'm going to have any issue as far as bond conditions or anything like that. I don't have a secretary. You know, I've never done this. I'm learning every day as much as I can, and I do understand that I'm a one-legged man in a race against an Olympian. I understand that I am not going to become a lawyer by Googling it. You know, it is going to, but the more time that I can have, the more prepared I could be. like I said, I don't see an issue with anything to where that would change, and I am not requesting a speedy trial either.
All right. I think, 90 to 120 days is probably what we would be looking at. So we'll set it out at that period.
Thank you.
Ms. Koch, how many days on trial?
1.
Besides yourself and possibly your wife, do you have any other witnesses that you'd be calling?
I did have a question about that, Your Honor, and that's my brother, who I had talked to on the phone that day, would like to know if he could write just what we talked about and not be present. He has fear of coming in, of repercussions, to be honest, and he would write that as well if that was necessary.
That's not typical. Usually witnesses have to be here in person to testify.
Yes. Okay.
You could certainly try that. I suspect Ms. Koch would object, and I'd have
Fair
to
enough.
make a ruling on it.
Fair enough.
So I can't tell you yes or no sitting here right now.
Yes, Your Honor.
Because she could agree to it for some reason. So
Yes, Your Honor.
that's a discussion that you should have with her.
Okay.
And if you want to introduce that kind of handwritten testimony at trial, again, I'm sure she would object, and then I would have to make a ruling.
Yes, Your Honor.
Okay, so I'm going to set it for a one-day jury trial at about 90 to 120 days out. And so, Mr. Marvin, you'll get a letter from the court that gives you that trial date once we have that. I'm also going to set it for a final conference. And that's just, one more opportunity for us to be in court to address any issues prior to trial. And to the extent that you would want to consider or different plea offers, that would be the final date to do that. And then also the final date to file any motions. So that final status conference, you're going to get 2 different dates. You're going to get a date for the final status conference
And then one for the court.
for the trial.
To try.
So that final status conference, if you have any motions, they all need to be set for hearing no later than that date.
That'd be for evidence as well, to get evidence and.
Yeah, any kind of motion
Okay.
that you would want to file.
Yes, Your Honor.
And you're also going to get a copy of the scheduling order that explains to you all of those things.
Okay,
as well.
thank you.
And then there's also some instructions in there about providing witness lists and those kind of things. So just make sure you read through that, okay?
Yes, Your Honor.
All right. Ms. Koch, anything further that you need to address for the record for yourself?
I will amend the information. We did just get the marijuana lab to say intoxication by alcohol and or marijuana. And I'll send a copy of that to Mr. Marvin, and we can discuss any questions he has about the procedures that you set forth today. He'll probably email me.
Mr. Marvin, anything else I can address for your side?
No, sir.
Thank you. That's all for today.
Thank you. Thank you.